Hi everyone, Gene Richards here again, attorney from the Williams Law Group, and we're back on the Navigating DCPP podcast, the podcast where we break down complex issues involving the Division of Child Protection and Permanency, or DCPP. Today we're going to speak about inside the courtroom. We discussed a lot on this podcast, what happens pre-litigation, different ways of investigations, what that looks like, what can happen next in those investigations before litigation, removals, things of that nature. I'm going to discuss now more so what happens once you now find yourself inside the courtroom. Before I begin, I want to remind you all out there that no information that I share in this podcast creates an attorney-client relationship. But we do welcome any person involved with a child welfare agency, that being DCPP, to contact our office for a confidential consultation with our team. So you have DCPP involved in your life, whether it be through a removal or just an investigation. And DCPP decides that we're going to take you and your family to court. What's that look like? What should you expect? What's the timelines? Well, starting with these DOD hearings, right? We discussed last week and the week prior about removals, right? If an emergency removal happens, you have to then be in court within 48 hours or 2 court days of that removal. And the division will ask for custody, care, and supervision over your child or your children. So DCPP files this complaint for custody because they removed your child from your care. The judge will then look at why DCPP removed the child and decide if that removal was legal and necessary. What was this? Did this have to happen? Was this child in imminent risk of harm? And if not for DCPP's removal, this child would have indeed been harmed or at imminent risk of being harmed. Now, this removal hearing is fast, and sometimes parents don't even have a lawyer yet. And what I mean by that is that you might show up to court because it happened so quickly without a lawyer. And you're then appointed some public defender, someone who you haven't even talked to perhaps, who's there just to kind of cover the bases and to just be there and say a few things. But it's critical because this hearing can set the stage for everything that follows, right? For example, if the case goes well, the hearing goes well, your child could be back in your care. If it doesn't go well, then you have to begin the process of figuring out how to go through the different loops or hoops and hurdles and getting your child back in your care. Now, this complaint's filed and you might get a 35, 40-page document the day before court, and you have to kind of review it and get ready, because at this hearing, sometimes the worker will testify as to the contents of the complaint and if the removal was then justified. Now, a similar hearing, right, it's the initial first hearing. When there isn't a removal, the division will still file a complaint for care and supervision, right? They're not having or asking for custody of your child. They haven't removed your child nor do they want to, but they believe that your family needs to have the division and then the court involved. And in these initial hearings, it's really the order to show cause. Again, DCPP files a complaint requesting care and supervision. And just like in the prior hearing we discussed, there's a complaint. To get the complaint right before court starts, worker testifies as to why the court and DCPP should be involved, and the court decides, yes, DCPP should be involved, and yes, the court should be involved, and therefore we're going to schedule upcoming hearings. And so, again, this hearing happens so quickly. How the case starts off in court can determine how it's going to go moving forward. So it's important to have seasoned counsel retained as soon as you get a complaint. Really, it should be before you even have a complaint. But unfortunately, many people don't seek counsel until they figure out, oh, I'm going to court, I need an attorney now. Really, you should have an attorney before you're even thinking about court, even in the investigation. Sometimes people don't think it's important till you get a notice for court. Now it seems so real. I have to be in court. Now I need a lawyer. It's really urged to have one prior to that, but oftentimes you get the need in your mind to say, okay, I'm in court. Now I need a lawyer. And you have that lawyer to hopefully review the complaint within a day or two and be ready for court. And so fortunately, if your lawyer has experience with DCPP, that lawyer can easily review a complaint quickly, prepare questions for the caseworker, talk to the DCPP's lawyer, and get things done fast. If your lawyer has no experience in how DCPP works, well, then most likely your lawyer will go to court and not know what to say, what to ask, what the complaint's about, and it's probably going to be a mess. And unfortunately, the first hearing, as I said before, will determine how the case progresses, what happens, if anything, next. And so when DCPP files a complaint, that order may also, the initial hearing may determine things like custody and visitation and what services are being offered. And there will then be compliance reviews to determine, okay, has this person complied with hearings? Has this person complied with the services? And it can get very complex, right? Because there's different kinds of tracks a case can take, and I'll get into in other episodes. It's Title IX versus Title 30. Is this an abuse or neglect case? Is this a case where a family just needs services? And this really can go a million different ways. I'm giving you just a quick overview of kind of how the process can work, a very skeletal template in terms of how the hearings work, what they're called, when they happen. And so once you have the order to show cause and a return date, usually 14 to 21 days later, you'll have compliance reviews. Is the party, are the parents complying with the court order, complying with services? You'll then have, if there was a finding of abuse or neglect, a fact-finding hearing. This is the trial, pretty much, right? So if you've been established or substantiated for abuse or neglect, there will be a fact-finding trial, a fact-finding hearing set, where the judge will hear evidence from everybody: the division, the law guardian, defense counsel, right? DCPP will show their evidence, their witnesses, and your attorney has a chance to challenge that, cross-examine witnesses, present your side, argue your position, even have you testify if you so choose. And these trials can happen somewhat fast. I mean, it depends on how you look at things, but if there's been a removal, this trial has to happen within 4 months of that removal. Supposed to anyway. Of course, there's give and take, but it's really supposed to happen within 4 months, or about the 4-month marker of that removal. If there's not a removal, then that fact-finding trial should happen around the 6-month marker, within 6 months of the case being open in court. And just like the other hearings, the result of this fact-finding trial can determine what happens next, right? First of all, if you've been substantiated for abuse, if you lose that trial, well, you'll be substantiated. It's on your record. If you win that trial, well, then okay, you're not an abuser. You're not neglectful of your child. It's obviously a big deal. So the trial has really twofold consequences. One, the finding of abuse and neglect, and two, how the case proceeds, right? If you win the trial, then perhaps the case gets dismissed as well with that. If you lose a trial, well, you have the finding of abuse and neglect, plus you have to now do more things to get your child back or to have the case closed out. Because once the fact-finding trial is done and the court decides what's going to happen next, or next hearing, it's a dispositional hearing. And at that hearing, that's what is determined, or when it's discussed what's going to happen next. Okay, you lost a trial or you won the trial, but there's still maybe concerns of services even if you won the trial. And so this hearing discusses what's going to happen next. What's the plan? What services do the parents need to complete? What's the goal? Are we working towards reunification still or something else? And how to work towards that reunification goal if there was a removal. And again, once you have those services in place or those required court ordered services, you have compliance reviews. And again, the court looks at is the parent or parents following services, following the order? Is DCPP following the court order? Is the child safe where he or she may be? And so it's important that when something is ordered, I discussed it before, that you follow a court order. Because if you're not complying with a court order, then these compliance reviews will not go that well. Now, at the year marker, say back to removal cases, right? If there's been a removal and your child's still not placed in your care, well, at the year marker, the court is supposed to have a permanency hearing where DCPP advises the court of what is the permanency plan. What's the long-term plan for the child? If it's not to have the child back in your care through reunification, DCPP might recommend a different goal, like guardianship with a relative, adoption, terminating your rights, independent living. So there are many other options of permanency that don't involve your child coming back in your home if your child has been removed from your care. And really the worst case scenario is if the division decides to attempt to terminate your parental rights. It's TPR for short, where the division can file a complaint to terminate your rights and then have a TPR trial and attempt to have the court permanently sever your legal rights to your child. And obviously that's the worst case scenario. And fortunately, it's a very rare occasion to have those trials or those trials even then be granted. But I unfortunately have been part of those trials on many occasions. But if it does have to happen, you have a lot of time until that is the case, right? There's a lot of hearings and time to get things right first. But again, time matters. So you can't keep waiting and delaying and not doing anything or saying, I'll get serious about this later. I'll stop drinking one day. I'll do my services later. Everybody's wrong. but me. If the court order says do it, well, guess what? You better do it, because if you don't do what the court order says and there's no stability in your home and no compliance with court order, well, then unfortunately, these cases, although it takes time to get this far, they can lead to having your rights be terminated via a TPR trial, via a guardianship complaint being filed by DCPP. It's important. It seems so far away, but you'd be surprised how fast it can get there. I've been in a case from beginning to end where sometimes the court and DCPP try to fast track the case, right? They try to say, well, these kids want out. This isn't a safe home. Let's terminate rights quickly, right? Although there's time frames and timelines, these timelines are flexible and fluid. If DCPP and the court want to push things faster, it can happen that way. They want to delay things, it can happen that way. So it's important to have a lawyer who can help steer the ship in the right direction, right? If DCPP tries to push for a termination trial quickly or too quickly, say, hold up, no. My client still has time to do evaluations, to have her own evaluations, to have more screens, more services, more parenting time, right? So it's important to not allow the division to dictate how the case goes, because there's cases where they want to have a TPR trial happen way too quickly, or have a child's position be the end-all be-all. It's not up to a child solely where they end up being. It may be a factor depending on their age, and it may have more weight depending on their age, but it's not up to just them. And so it's important to realize and advise the court that it's not just up to DCPP how this case goes. You have your rights, you have your position, you have your attorney, hopefully, to voice your concerns and position to the court. And it's important to advise the court of you doing the right things, and just, I need more time, or I have done these things. DCPP is saying I haven't, but I have. Here's proof of that, right? But you have to have the proof. Anytime you have clients where you say, I'm doing these things, believe me, where's the documentation? Where's the proof? Because the court wants to see that. If I tell the judge, my client's complying, my client's done this, but there's no proof behind it, it doesn't mean too much. Would I lie to the judge? No, but my client could lie to me, and the judge may say, well, I hear you, Mr. Richards, but where's the proof? If I have documentation, I can give it more weight, and I can find credibility to your statements and your client's statements. And so it's important to continue to voice to the court what you're doing, how you're doing, and provide proof of those things, because before you know it, you'll find yourself in a permanency hearing, you'll find yourself in a TPR trial, and before you know it, case is closed out and your rights have been permanently severed. You can appeal things and hope for the best, but that's even a longer process. So once you get to that point, it's even more of an uphill battle to get your children back in your care. It's a flawed system, as these things always tend to be, because this timeline, this time frame, it's somewhat flexible. It's not rigid. So things can be delayed, things can be hurried. And so it's important, based on your case, sometimes delays are good. If you're not ready, or if there's not been compliance with everything, or there's a pending evaluation that can benefit your case, delays can be good. They can also be bad, though. So it's a case-by-case basis, how to kind of steer the case, how to make the timeline work for you. And it's important as counsel for somebody to ensure that that's what's happening. And we, as the Williams Law Group, we definitely, based on our experience, know how to best kind of direct the case, right? Is a delay a good thing? Should we hurry things up here? Are we ready to kind of be on the attack, or on the defense a little bit here, because things are still pending, right? Our expert hasn't had the report yet, so hasn't given us the report yet, so therefore we can't have trial tomorrow. The report's still pending. So different factors can determine to speed things up, slow things down, because whatever it may be, you want to be in court prepared, because all these hearings I discussed earlier, what happens there, again, it's like building blocks, right? It's like building a house, a foundation, a building. If the first hearing goes poorly, you're on a bad foundation. You got to fix the mess at that point, and you keep building upon that. And before you know it, you're at a TPR trial on a rocky foundation, a rocky building, and nothing to stand on, and the case crumbles. And so it's important to keep building on hearings going well, keep building on orders progressing towards what you need, whether it be lifting supervision, or having your child back in your care, or having services be completed. It's about building those orders, stacking them up, good hearings, and moving forward until that case closes out. Because if you have cases and hearings where it's not going well and you're going backwards, like I said before, the case is going to most likely end in a bad way. Or you start doing the right thing and complying, that case is not going to most likely end very well. So I want to, as always, thank you all for listening and just chiming in and always joining into the weekly podcast here. Feel free to listen again, to share, to subscribe, and let your friends know. We discussed today what happens in court. Many different hearings. I didn't even touch them all at all. There's more hearings to discuss, and there's more paths a case can take with DCP&P based on what kind of case it is. But we did touch base on a number of the hearings and what they entail. And so it's important for people to know, because if you find yourself in a DCP&P case and you don't understand these hearings, because they are very different than your typical family court case. And these names, these hearings, they're not commonly known, right? If you have a lawyer who helped you in a custody case or matrimonial matter, these hearings may be completely unknown to them. These words, these terms, it's not commonly known by those who don't practice in DCP&P cases. So please, share, and so that those who know you can know this information as well. If you want to have more resources or support from our office, we have our website. We have the hotlines to call for assistance. If you need help in a DCP&P case, give us a call. Be happy to assist you and your family in those cases. Now, next week, we're diving a little more into detail. I mentioned earlier about Title IX versus Title 30. We're going into a little bit of that intricacy, but focusing on Title IX, which deals with neglect and abuse. And so you hear those terms, well, what isn't neglect? Or what is neglect? What is abuse? So neglect versus abuse. What's the difference? How does that dictate how the case goes? Is one worse than the other? Well, we're next week, and we'll hear about that from the podcast from me, and I will look forward to sharing that with you all next week. Until then, have a great week.